السلام عليكم ورحمة الله وبركاته. بسم الله والحمد لله والصلاة والسلام على رسول الله وعلى آله وصحبه أجمعين. أما بعد, shall we continue with the laws of inheritance? This is our third session, right? So we mentioned that in the laws of inheritance, the heirs are specified. Allah Azza wa Jal, He specifies the heirs, those who would inherit from the estate of the deceased, right? But what factors qualify that qualify a person to inherit? A person can only inherit on what? Two bases, but through what? Lineage or through what? Marriage. When you speak about marriage, that is specific to husband and wife. Specific to husband and wife. So a person being a spouse of the deceased, a husband or wife of the deceased, that would entitle him or her to inheritance. And the second factor is that of blood relation, lineage, right? Blood relation, nothing else. Alright, so the definition of an heir, the heir is that person is entitled to inherit from the estate of the deceased because of his or her connection to the deceased, and this connection could be through blood relation or marriage. Alright, so if that is the case, then there's no inheritance with regards to any foster relation, right? Fosterage, suckling, adoption, in-laws. So you don't worry. Mother and father cannot inherit from your estate, don't worry. Right? No in-laws, ex-spouse, ex-wife. The marriage must be valid at the time of the decease, at the time of the demise. At the time of the demise, the marriage must be valid, meaning when they were husband and wife until one died. Alright? Not that, okay, they divorced, the marriage came to an end and terminated, thereafter one died. Alright? That in-laws part? Go ahead.
Or that they already have children, they have small children, and these children living with you now because they school, and your children and these children together. This will be your child or inherit that or no?
No, your children is your children. I mean what? If a person married somebody, right, marries a woman, and that woman has children from a previous marriage, right, the lineage, the paternity would be established with her husband, right? Her husband would be what? The father of those children, right? Paternity would not be attributed to the new husband. No, so what will happen over here? They would not be your children, right? They would be her children, right? So if you were to die, then they would not inherit by virtue of being heirs, right? They are not your children. Yes, and they get rewards and they get blessings, right? As we mentioned, inheritance is what? Strictly through what? Blood, right? Blood relation and zawjiyah, marriage, right? And when we speak about blood relation, inshallah, with upcoming slides, we will see this has nothing to do with what? How obedient the child was, right? So you grow up a child from small. It's not your child from small. And that child what? Do your khidmah until you die. And your own child what? Didn't do anything. When you die, who would inherit? Your son, right? Your blood son, that your son, he would inherit. But if you want, in your lifetime, you can give to this child. As we mentioned, a person in his lifetime, whatever he wants to do with his wealth, that is up to him. Who he wants to give, that is up to him. But the moment he dies, khalas, that is an automatic transfer. That person has no interference anymore. Alright? Right, so if they have they would share, right? So whatever is allotted to what? The son, they would equally share in that portion.
Okay, so they share that the wife supposed to get.
Right, the wife would either receive what? 1/4 or 1/8 of the estate, right? And if it's multiple wives now, they would equally share, right? They would equally share that 1/8 or that 1/4. So an ex-spouse, illegitimate child, a child born out of wedlock through zina, fornication, that child would not be what? Would not inherit. Understand over here, not every illicit relation, not every child that is born from an illegitimate or illicit relation, a haram relation, is void of paternity. Alright? We explain that. The Prophet ﷺ mentioned al-walad al-firash. A child is attributed to what? That mother, always attributed to the mother, whatever the case may be, right? But whosoever has what? Rights to the mother, to that woman, right? And for a woman only one man would have all rights reserved, that would be the husband. So whatever comes out from there is attributed to the husband. So whether that, just not whether, but listen, if perchance in the event that that woman committed with an illicit relationship while being married to someone, and she committed what? That haram act of zina, adultery, and because of that she becomes pregnant and she gives birth to a child, that child belongs to the husband, not the outside man. Right. Well, everybody get attentive now, subhanallah. Right? Al-walad al-firash. Right? That woman, her husband has, so that is what? All rights reserved to him, for him. Right? No one has rights to that woman, right? Except the husband. Right? Listen, you can't come in my yard and plant something and say it's yours. Right? If you come in my yard and plant something and plant it, that's your tree. It's in your yard. Right?
If the man burn,
Huh?
if the man burn,
Still, it's connected to the once. Understand here, once a nikah is established, right? Once that nikah is established, whatever comes from the womb of that mother, that woman is attributed to the husband. Yes, the husband has what you call the right to vow to disown that child, right? But that is a process that calls the and with that now the marriage will be terminated and terminated permanently, right? You go through the whole process of what? Because you got to accuse her of zina and fornication, and she would have to give oath that what? She didn't want to do that, and you would have to testify that she did that. Right? It's mentioned in the Quran. And after that whole process of li'an, it takes place, that is a permanent separation, right? Between what? Husband and wife. And the paternity would not be attributed to the husband. But that, without that process, right, the paternity will be attributed to the husband. Right? That would be his.
So when the boy is born,
and he's looking like, right, it doesn't matter, right? Listen, you think that's strange? A person would say, okay, what about DNA if DNA proves otherwise? That has no, we won't say it has no bearing, but that is not the decisive factor. Right? Once that marriage is there, right? And more strange than this, right? Zaid gets married to Zainab, right? Then Zaid went away, right? He went away, he went to pick apples, right? Then when he come back, he sees Zainab what? Pregnant, right? She gives what? Birth to what? That child. That child is attributed to Zaid unless he what? He negates the paternity. And in understand, negation of paternity is what? Accusation of zina. Right? So that whole process of li'an, if it takes place, that marriage will be permanently separated, terminated, right? And yes, the paternity would not be attributed to Zaid. That child would be what? Fatherless, right? Also, our unmarried woman, we see we jumping the gun over here, they're not part of this, right? But it's coming up later on, but since you bring up the discussion, right? Understand, an unmarried woman, right? An unmarried woman if she has what? Illicit relation, obviously it will be illicit anyhow if you're unmarried, right? If she has relations and due to that relation she becomes pregnant, right? Due to that relationship she becomes pregnant. That child, as we mentioned, in all conditions, the child is attributed to the mother. In all conditions, they never have a motherless child, right? That's not possible, right? But who would be the father of that child? That child has no father, right? Even though they're living together, right? The Sharia does not acknowledge the paternity of an adulterer, right? The hadith of the Prophet ﷺ, that adulterer is only one thing he would receive, the had for adultery, right? We know the had for adultery, the penalty for that, the punishment for that. So the paternity would not be attributed to him, even though he may be the biological father. He would not be the father of that child, right? He would not be the father of that child, that he cannot inherit from the child, nor can the child inherit from him. Why? Because there's no what? As we mentioned here, there's no lineage and there's no zawjiyah, so khalas, no inheritance.
And that applies even if they decide to get married after.
That applies even if they decide to get married afterwards, right? As I mentioned that, right? According to the Hanafi madhab, right? Aqal mudda al-hamal, aqal muddatul hamal, or muddatul hamal, the least gestation period is 6 months, sittatu ashhur, 6 months. The last class we mentioned the longest. It was this class, 2 years, right? Understand here, everything is attributed to the nikah, the date of the nikah, the time of the nikah, right? So if a person, two people, they had what? Prior to marriage, they had what? Illicit relation. And because of that now, the woman became pregnant. MashaAllah, we have the little tron listening here. Listen, the woman becomes what? Pregnant. Alright? That's before the marriage. Now they decided, hey, they had to get married. No, some people use as an excuse to get married. Subhanallah. No, this comes after marriage. But listen, it happened like that. The woman becomes what? Pregnant, and they decide to get married. So now, the ruling here now, if that child comes 6 months or more from the date of nikah, the paternity will be attributed to the husband, the man, right? But if that child comes less than 6 months from the date of nikah, the time of nikah, paternity would not be attributed to this man, even though he may be the biological father, right? He is not the father of that child, right? He's not the father of that child. Why? Because the least gestation period is 6 months. Right, so if that child comes what now? Less than 6 months from the time of nikah, the date of nikah, that is what? 100% proven that, listen, that came before what? Khalas, that before nikah, right? So even though yes, the woman takes a pregnancy test and she knows she's pregnant, right? And still gets married to the man, right? And the child is delivered after 6 months, right? Even though that occurred, but it will be what? Attributed to the nikah itself. And the nikah, that the date will facilitates it. So khalas will be connected to that. Alright? And more strange than that, if a woman would committed illicit relation prior to marriage with a person, with a man, alright, and she becomes pregnant from that relationship, right, then she chooses to marry someone else. Plenty drama, eh? She chooses to marry someone else, right, and after marriage, that child came after 6 months. That child would be attributed to the husband, right? Even though you take a DNA test and say, no, this is the biological father, that has no bearing. right? So we come back to inheritance, right? I know what others digressing. So yes, in your mind, no, wait now. People minor, people children. Yeah. So can nothing wrong with that. At least what if you could do that in a good way, spend on them, all right, give them good tarbiyah, Islamic upbringing. Listen, there is no ism and no sin and no fault on behalf of what? The child, right? Even when khalas, a child is born is sinless. Even a child, understand here, every single what human being is born sinless. Even when a child born from zina and fornication, that child is born sinless. Right? The sins upon what? The perpetrator. Now, sorry, we can continue over here. So there are three types of heirs. Alright? Three types of heirs. You have what they call primary heirs. Yani ashab al-furud. Primary heirs, they are called primary heirs because these are the heirs whose what? Shares are stipulated in the Quran. Right? Their shares are stipulated clearly in the Quran how much they would receive. So meaning what? They would receive their share first. Alright? First. Then we have what they call the secondary heirs. Secondary heirs, asaba. These are what? Residuary heirs. Right? Also you call them residuary heirs. These are the heirs who would receive their share after the primary shares receive their allotted share. It doesn't mean that the residuary shares they will not receive. No, but listen, if I give you a cake, right? I cut this cake in what? In 6 pieces, 7 pieces, 8 pieces. I said, listen, share to what? These individuals here. Give him 1, give him 2 pieces, give that one any 3, and whatever remain, you take it. That's residue, right? Your share not fixed, right? You don't have a fixed share, right? Residuary heirs don't have any fixed share. They receive their share after what primary heirs receive their allotted shares, right? And they have what they call what the tertiary, right, heirs, meaning what? You already call them the non-heirs. Why? Because they would only inherit in the absence of the first 2 categories, right? And rarely you would find, right, that category inheriting. Why? Because they would only be able to inherit if the first category and the second category cease to exist, with the exception of the spouse, which will be discussed later on, right? So we're not going through this whole, right, who are the heirs. Inshallah, we plan inshallah to have a follow-up to this, right? This is just the first part, the awareness and everything, but the actual what? Calculation, who wants to what? Learn how to calculate the shares, right? Inshallah, we'll have a special any session for that, not inshallah, but I'm sorry, we won't mention about that, right? But this after this class and after this whole session, inshallah, to actually check, right, who are the heirs, right, and how much each and every heir would get, and how you actually distribute the estate, right? We gotta charge for that, you know. Yeah, each heir has a specific an allotted share, right? Understand? We will speak about wills too, right? And there's many misconceptions and misunderstanding with regards to wills. Right? We'll clarify that inshallah. Certain things over here we just leave out, right? So somebody was asking the last class, okay, what about somebody was that kill the father? That was the question. So we mentioned, listen, yes, a person would qualify to be an heir because of what? Being a spouse or because of any blood relation, right? But there are certain factors that would what? Disqualify a person from inheriting. These are what? Mawani al-irth, the preventers and the impediments to inheritance, right? That will disqualify a person from inheriting them. Even though he is qualified, he has all the requirements, but this act, because of this, he is disqualified. This is a red card, right? So impediments to inheritance are what? Are 2, right? Basically 2, right? The classical books of what? In Fiqh, yes, they mention 4, right? This put it into what? Slavery, understand that, but practically there are just 2 impediments, right? 2 factors that would disqualify. One is what? Kufr, disbelief, right? And Nabi alayhi salatu wasalam, he mentioned لا يرث المسلم الكافر ولا الكافر المسلم. Right? A Muslim would not inherit from a non-Muslim, nor would a non-Muslim inherit from a Muslim. Alright? We explained that just now. Alright? Understand? There's a difference between inheritance and what? Will. Alright? Will, the word will has what? Many terminologies also. We'll explain that. Alright? When a person dies, there are 4 rights connected to his estate. The first right, as we mentioned, is funeral and burial expenses. That is taken out. If not paid by anyone, that is taken from his estate. The second is what? His debts. Alright? Debts are not what? Absolved by death. Right? Debts are not cancelled by death. Right? Some demand death to finish class. No. Right? So as we mentioned, the man died, leaving behind what? $10 million. So the heirs now, they're already, how are we going to spend this? We're checking it up, what are we going to do with that? Right? But the debts also is $10 million. There's no inheritance. Right? No inheritance. Right? It must go to what? The creditors. And this is something that, listen, we, subhanallah, right? If the man who died didn't know, right? The heirs, it is their responsibility. Man died leaving behind what? So many debts owing Tom, Dick, Harry, Mary, Barry, and Larry. And now when they come, khalas, they have no access to it. Right? But the thing about it, the deceased person, he left behind assets. Right? He may not have a what? A big bank account, but listen, a house, land, vehicle, these are assets. It must be what? Liquefy it and pay to the creditors, and this is their haq, this is their right. If we're not doing that, then we what? We robbing these people, mean what? We taking their haq and their rights, right? And this is something prevalent, right? We could speak probably what? A whole year or 5 years campaign of inheritance, in importance of inheritance in Trinidad, you will still have what? Malpractices, right? As you mentioned, it's difficult to part with what? You know, we like to give a little 500, a little 1,000, but when you see inheritance clocking the hundreds of thousands, millions, it's hard. The shadow will come and whisper what you could do with this and what you could do with that. You know what? And that's as we mentioned, you take the money that belongs to others and you know what? You donate to the masjid and the madrasa and you feed the poor and this and you feel what? You do a very good deed. And that talbisu iblis, this is deception from the shaitan. Anyhow, so what is mentioned here, this is what the second right. The third right is wasiya, will. And the fourth right at the bottom of the list is inheritance. That is fourth right to the estate. Right? This will part here now, this is where the deceased, he has a certain what? Any control over his estate after his demise. And this is restricted to 1/3. He can say, listen, right, when I die, give such and such asset or such and such to what? Zaid, Bakr, Umar, whoever. Right? He can stipulate beneficiaries here. Right? He has the allowance to stipulate beneficiaries. It cannot be heirs, not heirs, right? Generally, right? It could be what? Anybody stipulate, okay? He's going to get this, that. So once it doesn't cross 1/3, that will be executed. So this is he has liberty to that. 1/3 of what they call the net estate. 1/3 that remains after funeral expenses has been paid, debts has been paid. That amount that remains, 1/3 he has what? Liberty to that after his demise. If he doesn't leave a will behind, then all becomes inheritance. And inheritance connected to the heirs. Alright? So here now in this part we're speaking about, right, the net estate, right, you have the wasiya part, the will, and you have the inheritance. This inheritance over here, a non-Muslim doesn't inherit from what? The estate of a Muslim, nor will a Muslim inherit from the estate of a non-Muslim. Understand? But this wasiya part here, this will part, the will, he can make a will to a non-Muslim. Yes, he can make a will to a non-Muslim, so he can benefit from your estate by virtue of being what? A beneficiary, a musa lahu. that person whom yani a wasiyah was made to, and not yani by virtue of being an heir, because he's not an heir, right? So they can benefit from the estate, like Brother Zahir was mentioning just now, that child that he grew up, I mean that person grew up, right? But there's no blood, there's not the child, there's not the son, right? But khalas, if you want to give, you can give in your lifetime, but also you can put that child under what the wasiyah, right? But there's a restriction to the wasiyah, right? 1/3 of the net estate, right? And similarly, if a person has what? Non-Muslim parents or relatives and they pass away, right? Understand here? When we say a Muslim cannot inherit from a non-Muslim, what it means, understand this in here, it means what? You cannot claim from that, right? You have no claim, no legal claim to it. But listen, if they decide to give you, khalas, take it, right? You're not going to put them in court or whatever and claim, you have no legal claim to that, right? But if they want to give, right, if they want to give it to you, khalas, it will be considered any hadiyah as a gift. Right? Why? Because that will be connected to what? These beneficiaries, right? The non-Muslims, the non-Muslim beneficiary, right? from the relatives. And if it is connected to them and it's their haqq and their right, and they want to part with some of it to the Muslim sibling, right? That is what? A hadiyah, that's their gift. Alright? Is that what it means? It doesn't mean, okay, I can't take it, it's haram. No. Right? You're not entitled to it. Right? But if it's given to you, right, you can receive. Two questions.
So let me say the child was somebody else's, but if the child was born after the 6 months, after the nikah, that child becomes an heir as well? Or?
Yes, that child, because the paternity will be established. The fact that the husband would be the father of that child is an heir. Because that's his son. That would be the daughter.
So the next question. You say the heirs cannot be included in the will. So
no, and that will be what? Any clarified, unpacked inshallah when we speak about the will. We'll take 1-2 sessions just speaking about the will. Because there are many misconceptions and regarding the will. What is exactly the will? And the will has many implications too. Right?
So that means the will can't include any children or any will.
Understand, the will itself, understand. I don't want to go in the will now, right? We just put a pin on that will, right? Right? I probably might speed it up then, put the next class, but wills, right? So the second impediment is killing, right? The killer will not inherit from the estate of the victim, of the killed, right? So killing is an impediment to inheritance. So you have different types of killing. Yeah, in Trinidad too. Right, so different types of killing. You have what? In the books of Fiqh also, in the qatl al-amd, right? A person intentionally kills someone, right? But understand here, qatl al-amd or amad, killing with the intent of killing, right? Understand, you don't ask the killer, so you really intend to kill him. He will say, no, I didn't intend to kill him, right? So you don't ask for the intent of the killer, right? If a person kills with a weapon or any instrument that is normally used for killing or that can kill someone, it doesn't matter what is his intent. That is an intentional killing. That is a killing with intent, right? Even though I mistakenly pull that trigger, that is killing with intent, right? So killing with intent is what? Or killing using what? A weapon that is normally used to kill, right? Or killing someone, right? Intentionally, but not with a weapon that used for killing. You see him on the road and you have you drive over here, but this class is not children class now, right? Right, so all that comes up, different types of killing over here, right? So a person kills somebody, right? Not with something that is normally used for killing, but the intent to run him over with a cow, beat him until what? Right? Also, what would fall under what? A killing that would be an impediment to inheritance is what? A person he mistakenly kills someone, right? So, even though he may say mistaken, that is between him and Allah, right? But with regards to inheritance, no inheritance, even though khalas, it may be mistakenly, give him the benefit of the doubt, they're going hunting, right? Or people are going hunting and he thought, well, he sees a deer or something, right? And he shoot and kill the man, and that's his father, his grandfather, right? Khalas, no inheritance. Even though if it is just, I mean, give him the benefit of the doubt, he would do that willfully, right? But even though he didn't do it willfully, right, and he can prove he didn't do it willfully, and he says he didn't do it willfully, right, still, he will not inherit from his estate, right? Because that doubt still remains, right? That element of doubt still remains there, right? This man taking long to death, I want to come go hunt now. Right? You don't know, right? But just because of that spectacle of doubt, right? No inheritance, right? This also over here we see that what? And could be a total accident also, and this what? This will also be an impediment to inheritance. For example, what? Somebody fall and roll over somebody and kill them. Listen, a little child, right? You sleep over, you roll and you just roll over and you kill that infant, right? So someone accidentally, right? But still, you will not inherit from his estate, right? That person will not inherit from the estate. Wounds his victim, thereafter succumbs to his wound when he dies. For example, listen. That person, he was wounded by another. He didn't die, but after a while he succumbed to the wound and he died. Right? No inheritance. No inheritance. So there are certain types of what? As Uncle was mentioning, certain types of killing that will not prevent inheritance. Right? For example, self-defense. Right? And that's, you have to prove that. Self-defense, the killing of a minor, understand? Not the killing of a minor. The minor over here is the what? The fa'il, meaning what? The doer, the killer, right? If a minor kills, right, that minor would not be what? Deprived of inheritance. A non-baligh would not be deprived of inheritance. A lunatic, a madman, a mad person, because a mad person, what they have in common, a mad person and a minor, what they have in common, they're not mukallaf, right? Subjected to the laws of the Sharia. So, yes, he may be penalized or what, this and that, but that person would not be prevented from inheritance. A person dig a trench, a big open trench, and someone fell inside it, and he died. So the one who dig the trench now, you can't say that, listen, he's the killer, and he would say the one who dig the trench is a relative, right? That was legally inherit from that one who fell inside the trench and died, right? In that case, this would not prevent inheritance, right? Because he didn't actually what? Actually, he wasn't the actual person that what? Killed him, or who actually killed him. He wasn't the actual reason, right? He died because of falling. A victim dies in a vehicular accident in which an heir was the driver. So a person driving and on the passenger side or the vehicle itself is someone who could what? Legally inherit from him, right? Or vice versa. The vehicle gets into an accident and a person died. So we can't say, okay, the driver, he is the cause, even though the police write it off, reckless driving, right? Still, that would not prevent any, because he wasn't the direct cause of the death. Death caused by an animal owned by an heir. A person has a dog, right? Somebody come by the house, whoever, the dog what? Maul that person, kill that person, right? That does not prevent, because he didn't actually what? Cause that. A person what? Was burnt to death by a fire ignited by someone, by an heir, alright? No. So we have a little riddle, not riddle over here, question. Alright? Here it states that, listen, and we always ask every year in inheritance class and we get good answers. Alright? The killed may inherit from the estate of the killer. How that possible? The killed may inherit from the estate of the killer. And did that pass a little bit and come back to it, or come, think a little bit now. The killed that may inherit from the estate of the killer. How that possible? Or what nonsense he's saying here?
Person killed, he that he owed a person. Who killed her? Who killed? So they say, I killed him. I remember that.
Okay.
So he died. So I responsible for the family.
No, here we're not speaking about any metaphorical, any figurative thing. No, it's literally inherit from the estate. The killed that may literally inherit from the estate of the killer. Right? Yes, so how that possible? The killed, the one, when I say the killed, the one who died, right? From that killing. He may inherit from the estate of what? His killer, the one who killed him. If the son killed the father, who alive? The son will not inherit from the estate of the father. He will inherit because of what? Killing, he will not, right? Blessing for killing who? And you think about it, right? The killed may inherit from the estate of his killer. Alright, we're going ahead. So understand a person, what we mentioned earlier, that what, listen, in the presence of certain heirs may be deprived. Right? There are those who are given preference, any precedence, right? First priority. So in their presence, other heirs would not inherit. For example, in the presence of what? The son. Right? In the presence of the son, no grandchild would inherit. Right? No grandchild would inherit in the presence of the son. No uncles would inherit in the presence of the son. Right? No brothers, no sisters, whether they full or half, would inherit in the presence of the son. Alright? So in the presence of what? Certain heirs may be deprived. Whether it be what? Partially or totally. Right? But if that heir now is a disqualified heir, for example what? The son killed the father. He is now a disqualified heir. So even though he is present, he would not have no what? Effect. Right? He will not cancel off anyone. His presence is like his absence. He's like he's dead also. Right? So he's not going to what? He's going to do what? Be disqualified. He's not going to inherit. And secondly, he's not going to have any ta'athir, any effect over the inheritance of the others. Alright? It's as though he's not what? Alive also. Right? Huh? What is that? You talking about the first thing you mentioned? The killed from the estate of the killer. No, understand over here, listen. When a child born, right? A child born and lived for what? For 2 minutes, 1 minute, and then that child died. That child has an estate? Not so? That child. For example, listen. A child what? If what? For example, that child, say the father died. Right? The father died leaving behind a pregnant what? Wife. Right? And that child, if that child was born alive, then that child would inherit from the estate of the father. Alright? So if that child came out alive, his share of the estate is attributed to what? To him. Right? 30 seconds after that child what? Dies. Right? That child has what? Half the estate or 3/4 the estate of his father already. Right? Now if that child were to die, his heirs would inherit that amount. You understand? So you say, okay, that child now come, he lived for 30 seconds in the world, how much, what he going to inherit? So in this case, you listen, the killed may inherit from the estate of the killer. Listen, two people what? Say father and son then, right? Father and son, right? Or two other people, right? One intended to kill the other. But what happened? He wounded the other, right? He wounded one, right? So that person now, understand the word killer not given to him yet, right? Zaid and Omar then. Zaid what? Stabbed. Zaid stabbed Omar, right? Omar didn't die from that wound as yet. Right? Now, Zaid, he died. Zaid, who stabbed? Zaid is stabbed by what? Zaid. He stabbed what? Omar. Right? Omar didn't die from that wound yet, critical or in the hospital or what? Right? After a few days, what he said, Zaid what? Passed away. Right? Omar being an heir of Zaid, right? Omar will inherit from his estate. You understand? Then afterwards what? You have what? Zaid, right? No, here is Omar. Omar what? Dying from that womb. So we see here now what? The killed inherit from the inheritance from the estate of the killer. Alright? Understand when Omar inherited from the estate of Zaid. At that time, he ain't called Zaid the killer yet because Omar didn't die. You can't call him the killer, right? But when you say, okay, when you see that Zaid died, succumbed to his wound, then how he died? How Omar died? Zaid killed him. Zaid become the killer. A trick question. Okay.
Omar wasn't killed as yet.
Okay. No, right? If Omar, right? If Omar died before the demise of what? Zaid. Omar died first, right? Omar died first, right? So Omar died first. Right now, Zaid doesn't have an estate because Zaid is still alive, right? Understand? Zaid is still alive, so Zaid doesn't have an estate as yet, right? His estate would only be distributed after his demise. And when Zaid dies now, Omar would not be part of it. Why? Because he died before the demise of Zaid. So he would not be part of the estate.
So none of the heir of Omar could go to Zaid and say, well, you killed my dad or whatever, you killed my brother or whatever.
No, that's different. Blood money and qisas and all of that is a whole different thing over here. We're speaking about being how you call it? Heir must be what? Alive. Understand? Listen. A father has 3 sons, right? Forget killing here, nobody killing nobody again, right? A man has 3 sons, alright? And one son died in the lifetime of the father, right? 3 sons, what? They married and have children, right? They married and they have children, right? Thereafter, what? One of the sons died in the lifetime of the father, right? So if he died in the lifetime of the father, they had no estate of the father being distributed, the father is still alive, right? That deceased what? Son, his estate will be distributed to amongst his surviving heir, right? Now, afterwards, after a while, the father passed away, right? The father passed away, right? So now the father passed away. His inheritance, his estate would only be distributed amongst what? These 2 surviving sons. Right? and not the what? The children of the son that passed away. Right? Why? Because we mentioned once the son is alive, they will be what? Grandchildren to what? The deceased. Right? So once the son is alive, the grandchildren will not inherit. Now, what is that? If?
In my case, you would have said the time. You can be going faster.
And not you happy? What do you say this? No, if somebody go and tell it. Okay. And then the laws of inheritance. Subhanallah. Yes, people know Hajj and Zakah and fasting and this and that, but at the time of demise, this is important, right? We speak about the religion of the heir. We have a little time, right? We mentioned the first impediment is kufr, right? A person not being a Muslim, right? Understand, everything over here is checked at the time of demise, when that person died, right? For example, this man has what? 3 sons. 2 are Muslims and 1 what? A non-Muslim. The father died leaving behind what? A huge estate. So upon the demise of the father now, the 3rd son, the one who was not a Muslim, Ashhadu an la ilaha illallah, anna Muhammadan Rasulullah, is a Muslim. Right? So good, Alhamdulillah. Understand, we're not looking at, we understand, we cannot say that a person accepts Islam for this reason and that reason. That is what? Totally prohibited for us to judge that. Right? Even though what? There may be somewhat indication that it's possible. Hey, why do it afterward? Why don't do it before? Why not? Why? So you can question, but listen, he's a Muslim, right? But the question is, there's a hadith of the Prophet ﷺ, this person, right? In the battlefield, he was what? Fighting the enemy, and he had the upper hand over his enemy. And the enemy what? He uttered Shahada, La ilaha illallah. And that person, that Sahabi, finished him off. Why? In his mind that what? Listen, he only uttered Shahada to save his life. Right? He didn't already utter that what? Sincerely. He uttered that what? To save his life. When that news reached the Prophet ﷺ, he reprimanded that Sahabi so much that he said, listen, he wished he didn't accept Islam until now. Right? That khalas. So much the Prophet ﷺ reprimanded him and rebuked him for that action. But that, hey, everything showing that, indicating towards, hey, I saw over you, hey, La ilaha illallah. Right? But even in that situation, no, we can't say what? He just uttered Shahada, right? To what? To save himself. No. So yes, come back to the what? This scenario here. He accepted Islam, reverted to Islam. Good, Alhamdulillah. We congratulate him, right? But the question is, will he inherit? Will he be entitled to inheritance? No. No. Why? Because at the time of the demise of the father, he was not a Muslim. You understand? At the time of the demise, he was not a Muslim. And they could flip it the other way around. The man has what? 3 sons. And he died. And before the estate could be what? Distributed, one of the sons to Murtad. He left the fold of Islam. Right? He left Islam. Wal-'iyadhu billah. Would he be entitled to inheritance still? Yes. Why? Because at the time of the demise of the father, he was a Muslim.
So what about, okay, last class we was discussing if somebody goes missing and disappears, you never see them again. If the son accepts Shahada after the person disappears, how do you determine?
If the son accepts Shahada after
the person disappears? Remember we saying if the person disappears, go missing. You wait however long and all the kind of different rulings.
You mean if what? He is the owner of the estate?
Right.
Okay.
And the son, after the person disappears and go missing, the son accepts Shahada, and after however long, they say, okay, accepted that the person.
No, khalas, once he accepted Islam, before what? It was ruled that that person died. Before the ruling was given, the verdict was given, yeah. Because whenever the verdict is given, khalas, that is the time of death. Now, so if after demise an heir left the fold of Islam, he or she would still be entitled to inheritance, right? And if at the time of demise an heir was not a Muslim, thereafter becomes a Muslim, right? He or she will not be entitled to inheritance from the estate.
If you, as I say, you cannot kill a person if the child is real or false. And you seem to put that in the case.
Right, understand? You have to see what the Prophet ﷺ mentioned, kufrun bawah, clear-cut kufr. You have to see that. For example, what? A person, we know he's a Muslim, right? But he don't come to the masjid. Not coming to the masjid doesn't make him what? A non-Muslim. But that person know him come for Jumu'ah. That doesn't make him a non-Muslim, right? But I never see this person. He don't know how to even give salam. He don't know even to recite Fatiha. But this man even know what the kalima, how to recite the kalima, right? Still, unless you see clear-cut kufr, meaning what? That person explicitly mentioned that he is a Hindu, he's not a Muslim, he's a Christian, or you see that person what? Prostrating to an idol, or you see that person going to church, right? It must be clear-cut, right? Otherwise, no. Similarly for janazah, same thing, right? A person died, right? You don't perform salat al-janazah upon a person if you have shak and doubt, right? No khalas. You always have that question, but that person, he never really come in the masjid, you know. No khalas. That person, if he died, understand, a person can die and be what a fasiq or a fajr. He's still a Muslim. But once he's out the fold of Islam, then it's not permissible to do salat al-janazah upon that person. The living will be what? Sinful if they do that. Alright? So khalas, what are you going to use? So long that person what? The asal is what? The principle, in principle he is a Muslim. Right? He known to be a Muslim. Right? Unless you see, unless what? We see what? Clear-cut kufr. Right? Unless you see clear-cut kufr, then you could say, listen, he's not a Muslim. Right? No janazah. Nah, silakan lagi. Saya interesting question. If
when a Muslim baby born, the Quran is born, right? Well, if somebody accepts Islam, and that then happens to them when they born.
Well, obviously that won't happen to them when they're born.
Well, how did janazah really?
Understand the adhan and the iqamah has nothing with janazah. People understand, some people, yes, they mention that as a way of khalas, that ibrat for a lesson, to think and to contemplate. Hey, that adhan and that iqamah that is sounded in the air, there's no salah after that, right? That adhan and iqamah is for salat al-janazah. No, there's not salat al-janazah, right? There's not salat al-janazah, right? So if a person, what, say a Muslim child now, adhan and iqamah was what, sounded in the air, they have no janazah. So when a person die now, hey, call the parents, but the parents will pass away too. Hey, this child, adhan and iqamah was called, that has nothing to do with janazah. Adhan and iqamah has nothing to do with any janazah. Right? So the question he mentioned is that if a person accepts Islam, in a non-Muslim, right, family, accept Islam, right, khalas, he's a Muslim, right, he may not be probably practicing and this and that or whatever, but once we don't see that person going back to his kufr or going back to kufr, right? We can't say that person is he just accept Islam and he already practice, right? You could say he already practice, whatever you want to call fasiq, fajr, this, that, whatever, but in fact remains he's still he's a Muslim, unless we could prove otherwise, clear. Right, so we spoke about the estate, right? The estate, what constitutes the estate? Every single asset constitutes the estate, right? Every single asset constitutes the estate, whatever he owns, right? That being said, you have the heirs now. So the heirs, their rights are connected to the estate. Listen, we have things that gender, okay, this is something feminine, that is something masculine, right? You have dress, you have jewelry, and you have, khalas, this is things, women things and that. Yes, that's what they are like, but whatever constitutes the estate is connected to the rights of the heirs, and the rights of the heirs, right, is connected to each and every asset of the deceased. So it's not like if the mother died, the jewelry would go to the girls and the vehicles would go to the boys. It don't work like that, right? It don't work like that. That's what? So the dress would go for the boys? Yes, the dress would go for the boys too. But what they go do with the dress, that is different. That's separate. Hey, you could own a dress without doing anything, a businessman, right? You could own, listen, we're not allowed to wear gold, but we could own gold, we could trade in gold, right? That could be in your possession, right? So it's not like, okay, we separated it into gender, right? The kitchen and the appliance and it don't work like that. Each and every asset, that one pin, right, is connected to all the heirs, right? The pillow, all the heirs, that is connected to, right? No heir can come and say, I want this, I want that. I used to drive this vehicle. My father used to and we know the father was allowed the child to use this item. That is in his lifetime. He didn't give it to you. He didn't give it to you. So if he didn't give it to you, it remains in his ownership. Being in his ownership, it constitutes the estate. Being part of the estate is connected to all of the heirs. Alright? All of the heirs. So you have whatever asset, you have you know what? You have the business. What the girls know about the business. They know how to run that business. That is irrelevant. Right? That is irrelevant. Right, the vehicle, but she didn't have a license. But this child only have 5 years. This child still going to school. That is irrelevant, right? Irrelevant. So we'll see over here the little complication when actually distributed, right? Well, that would come, that would take effect, right? We'll sort out that after. But the first thing over here is attributing the rights. Attributing the rights. This is theirs. Forget what they could do with that. The man live behind a pressure washer. So the brother come and take it. So where you going with that? Tanti can use a pressure washer. She can use a waka. Where she going with a waka? That is irrelevant. That is it belongs to what? The estate. Being part of the estate is connected to the rights of the heirs. You're not an heir, so you out. Right? So we have certain what? And you can go a little. What's that?
Something low. Like I say, assistant low.
Yeah, you don't worry about the in-laws. They're safe.
Same thing.
You're safe with no in-laws when they're married. Don't worry.
No, they did nothing yesterday. They never took care.
No, we mentioned that person could only inherit from the estate by virtue of being what? A blood relative or a spouse. You could leave something in the will. Alright? So we just touched on a few malpractices right? And probably you can give me some add to the list also, right?
The control and sharing distributing the
This is where the executor comes in, right? And the person that they put in charge, right? If none was appointed, then becomes what? The khalas, the responsibility of the surviving heirs. Right? So we always hear this, right? The person died and leave behind an estate, right? Leave behind a wife, daughter, mother, and father. So now, I don't know, for whatever reason, all of the property and the assets of the man, they just go to the wife. Right? You see that in certain cases, right? Nothing to the children, nothing to what the mother, nothing to the father, right? And they say, and nobody want to approach the wife because, hey, the wife's still grieving. The wife's still grieving, right? So I park my vehicle in your yard and you grieving. I have to wait until your grievance comes down and then I can take my car. No. So when I meant, okay, this about grieving and what, this is the emotional hype. Don't get emotional, right? So put the emotions one side and the laws of the Sharia. Yes, the woman is grieving and she has right to that, right? Right to grieve. Her husband passed away, right? But the Sharia here is no khala. She would what would be allotted to her, right? She's entitled to what? What is allotted to her by the Sharia? Right? She's going to get what? A quarter, 1/8. In this case, if there's a daughter involved, then she'll get 1/8. If there's a son involved, she'll get 1/8. The deceased had no children, then she would get a quarter. So all is okay. The wife's still grieving and that what? Listen, these are scapegoat, right? And afterwards, so you see what? Nothing inherited, right? Nothing passed on to what? Anybody. It remains like that. That is what? Totally haram and what? Not permissible. No, listen, understand here, a person will realize what the wickedness of his children after demise. He would know that in his lifetime. Right? So while he alive, he what? No, we get confused about here. Inheritance is when you die. Right? That is when you die. That's automatic. You have no control over that. Right? In your lifetime now, right? If you want to what? That your wife be comfortable after your demise and this and that. Khalas, in your lifetime, sort out. Right? If it's legal to? Right, so if you give her the house, you don't have to, we give an insurance. No matter what, you will still live in. Right.
If I in a case like that, make a will, right? I make it a will, my wife take it, sign the house and try to make out sign it. And if them,
we discuss, listen, when we come with the will, right? Understand the will part, right? We discuss that in details when we come to the will, because the will have what? It has two parts to it. The legal part and the Shari'i part. If you just make a will with the legal part and what, you neglect the Shari'i part, no, you can't do that. And secondly, if you make what? A will, a Shari'i will, right? And they're not in sync with what? The legal aspect, then what? You can't force it. So the two things need to come together. Yeah, but what I'm saying, you can't what? You can't make a will to an inheriting heir. that will be null and void. So the whole thing about wills and things, inshallah, will explain that. You can't say, okay, when I die, my son going to get the vehicle, my son going to get what? This land, right? Your son is your heir, so you can make a will to him, right? A shari'i will can go to him, right? But a legal will could go to that, but if the legal will contradicts the shari'i will, not still it what? It's not valid. So what you could do now, make a shari'i will and bring the legal aspect into it so that shari'i will could be what? Executed. And we mentioned we'll give a whole session or 2 sessions with just the wills, inshallah, right? And all whatever the wills and things, we'll deal with that, right? We need to first understand the concept of what? Wills, all right? We'll explain that, inshallah. We have many malpractices here, but we have no time, all right? We have no time. You have what? Listen, sometime what? You have the beloved son, right? Understand the titles, right? Why is the beloved son? That son did everything. He had 4 sons, right? But this one son, everything he did for all the khidmat and everything. And then 3 of them, you see them never come to visit, and then this, and you have all the words to say, right? And it's probably true, right? So when you die now, you give everything to the beloved son. You make what a will. When I say a will, remember, it could be enforced according to the land, whatever you write, right? So you make what a will now to this beloved son. No, that even though it would stand in the court, right? That is according to the Sharia, that is a null and void will. Why? Because they have 4 children, each will get 1/4 of the estate. You can't give all of the estate because what is they take care of you and did khidmat and that is irrelevant. Right, even though they beat you, what? That's your son. That's your son. Right? Listen, you're not giving enough. In your lifetime, you can say, "Not beloved son, all is yours." You could do that in your lifetime, but you can't leave a paper behind after you demise and say, "When I die, all will go to beloved son." No, right? In your lifetime, you want to compensate the beloved son. You could do that, but what if you don't do that in your lifetime? It remains in your estate. Then what? It will be distributed amongst all the children, beloved and not beloved. Although that will, it will be what according to the Sharia null and void. Because why are they depriving what? The heirs of their rights? The other son, the other children, they are what? The legal heirs. Alright? Remember the issues? We'll continue inshallah with the malpractices. Right? وجزاكم الله خيرا. السلام عليكم ورحمة الله.